Good afternoon, everyone. I'm Ralph Hexter, and I'm really delighted to welcome you to the fifth event in our 2013-14 series of the Provost Forums of the Public University and the Social Good. I think I should know that. We're very happy to be back with a second season of these forums, building on a great series that we had last year. This afternoon, we are privileged to have as our featured speaker, Dean Robert Post of the Yale Law School. In just a few moments, Professor Adedjun Mobi will give our distinguished guest a proper introduction, so I'll keep my own introductory remarks brief. I'm struck by the fact that Dean Post's lecture promises a type of benefit that most of us do not enjoy often enough, but for which there's very great need. It seems like every day someone, a member of Congress, a state governor, a political pundit, or even a once popular rock guitarist, offers some bold social analysis based on a reading of the U.S. Constitution. Often some controversial behavior is defended as constitutional or else described as a shredding of the Constitution. The good news is that we can derive from this trend is that the Constitution continues to be in the forefront of our collective political mind and continues to provide a framework for democratic decision-making. The bad news, there always seems to be bad news that comes with the good, is that too often our understanding and use of the Constitution leaves a lot to be desired. Best, we are guided by different but reasonable ideas of what the Constitution actually means. At worst, we are too easily swayed by ill-founded but attractive interpretations, or even cynically enlist the Constitution's authority to support positions we favor. So the first thing I want to say about today's program is that it affords us a rare and invaluable opportunity not only to spend some time directly contemplating our country's founding document, but also to hear one of its most knowledgeable and insightful readers discuss its meaning for our 21st century world. I'm confident that this forum, beyond shedding light on our announced topic, will also teach us to be better readers of the Constitution in general. Today's topic is of great importance and of interest to all of us here. I know of no single principle that is more essential to the health of a major research university, public or private, than academic freedom. We cannot do justice to our mission to advance and disseminate knowledge without the robust embodiment of this principle on all of our university campuses and without its jealous protection. The fact that Dean Post will place academic freedom in a constitutional context responds to the frequent arguments we hear within and beyond the academy, though not as far as I'm aware from rock guitarists, that depend on some sort of link between academic freedom and the Constitution. Thus, his lecture is a much-needed contribution to a dialogue that is already underway. Just as important, Dean Post's topic also helpfully reminds us that whenever we talk about an American university's academic contributions to the social good, we are always already addressing the social ideas and restrictions set forth in our founding document and system of laws. We might even say that our Constitution and its surrounding body of scholarship comprises a history of intellectual expeditions across many of those same continents, academic freedom being one of them, that our universities are currently engaged in exploring by other paths. There's much useful wisdom to be gained, I dare say, by our deeper knowledge of the discoveries made by those constitutional expeditions. I have to add that I personally welcomed Dean Post's visit for yet another reason. Before joining the faculty of Yale Law School, we were colleagues at UC Berkeley. It's always wonderful to reconnect with a former colleague, and even more so when that colleague is such an extraordinary individual and scholar. Before I leave the subject of today's program, let me remind you all that you are invited to continue the dialogue on academic freedom in the public university during a reception in the Yocha-Dahi Grand Lobby immediately following our panel discussion. Now, if I might, just a quick look ahead, the coming attractions, so to speak. Today's lecture will be followed by 4 more in this series, yet this academic year. In the coming months, distinguished speakers will address a variety of subjects related to public higher universities, education, and from a variety of perspectives. Among those subjects are the value and role of the humanities, the public university's contribution to regional development, and campus diversity. Our next forum on Friday, April 4th, will feature David Marshall, the Michael Douglas Dean of Humanities and Fine Arts at the University of California, Santa Barbara, and William Ladisaw, Dean of Humanities at the University of California, Santa Cruz. Deans Marshall and Ladisaw will speak on the topic, the humanities and the common good. Joining them for a roundtable discussion will be Margaret Ferguson, Professor of English at UC Davis, and this year the President of the Modern Language Association, and Christopher Reynolds, President of the American Musicological Society and a Professor of Music at UC Davis, and your sometimes humanist Provost. This event will be held April 4th, as I said, from 4 to 5:30 in the multipurpose room of the Student Community Center, with a reception immediately following. I hope that many of you will be able to attend not only that one, but the following lectures. If you do miss one, videos of all events, along with other materials, will be easily accessible on my website. And before I yield the podium, then, the happy task of thanking a number of individuals and groups. Of course, the organizing committee for the Provost Forums for doing such an excellent job in planning and arranging our events and squiring our guest. The two campus entities that have joined my office to co-sponsor this particular event, the Academic Senate Committee on Academic Freedom and Responsibility and the Community and Regional Development Program. Our moderator, of course, Professor Moradewon Adejun Mobi, a member of our African American and African Studies program, the chair of the Academic Senate Committee on Academic Freedom and Responsibility, and a member of the University Committee on Academic Freedom. Our two guests who will join me in today's panel discussion, Professor Emeritus of History Henry Reichman of Cal State University East Bay, who is also the first Vice President of the AAUP and chair of its Committee A on Academic Freedom of Tenure, and Professor Roberta Rehm of the Department of Family Health Care Nursing at UC San Francisco. And last but not least, of course, our great thanks to Dean Post for traveling here and speaking with us today. To all of you in our audience, thank you for being participants. And now I yield the podium to our moderator. Thank you.
Good afternoon, everyone, and welcome to this special event, our Forum on Academic Freedom. Before I continue, I'm required to make the following announcement. Please note the closest exit in case of an emergency, and please silence your cell phones. Thank you very much. Before we proceed further with the proceedings for today, some thanks and acknowledgements are in order. First, to the Office of the Provost of UC Davis for providing the wherewithal to organize this event. Thank you very much, which shows the commitment of the higher administration to principles of academic freedom on the UC Davis campus. Secondly, to the team responsible for organizing the Forum for the Public University and the Social Good, led by Professor Martin Kenny of the Department of Regional and Community Development, assisted early on by Alicia Thompson, and more recently by Casey Castaldi. Thank you very much for all the work that you have done. Finally, to the Office of Academic Senate, and especially the analysts for the Committee on Academic Freedom, to the Committee on Academic Freedom and Responsibility, Solomon Bekele, thank you as well. I would also like to acknowledge the members of the Committee on Academic Freedom and Responsibility present today. First, Larry Bogad from Theater and Dance, if he's around somewhere. You can see him there. Robert Berman from the Department of Neurological Surgery. Thank you. Christopher Elmendorf from the School of Law. Thank you. Eric Rauchway from the Department of History. I know he's here. Julie Meadows could not be with us today. She's from the Med School and a representative of Academic Federation. This afternoon we'll have first a lecture and then a panel discussion on academic freedom. On the panel will be Ralph Hexter, Provost and Executive Vice Chancellor at UC Davis, Roberta Rehm from UC San Francisco, and who is the former chair of the University of California System-Wide Committee on Academic Freedom, UCAF, Henry Reichman, who, as the Provost has said, is the first vice president of the AAUP and chair of its Committee A on Academic Freedom and Tenure. The final member of the panel will be Robert Post, and who is also our guest lecturer for today. Robert Post is a Saul and Lillian Goldman Professor of Law and also the Dean of the Yale Law School. Prior to assuming his position as Dean of the Yale Law School, Robert Post spent 20 years as a professor at the UC Berkeley School of Law, where he also left his mark on our APMs defending academic freedom, if you want to go and look at those APMs after today's event. His areas of expertise include constitutional law, First Amendment law, legal history, and equal protection. He has written and edited numerous books, including For the Common Good, Principles of American Academic Freedom, published in 2009, and more recently, Democracy, Expertise, Academic Freedom, a First Amendment Jurisprudence for the Modern State, published in 2012. Please join me in welcoming Dean Robert Post.
Thank you so much for that kind introduction, and thank you, Ralph, for this invitation. It's a really tremendous pleasure to be out here at back at Davis. It's you don't appreciate the heaven you live in, let me tell you. It's marvelous. So I've been asked to talk about academic freedom. Academic freedom has a number of different dimensions to it, but the particular dimension I'm going to talk about today is academic freedom in its constitutional aspects. That is to say, the aspects that come out of the First Amendment to the Constitution. And that's of particular importance, I would say, at UC Davis, because you're a state institution and, of course, governed by the provisions of the First Amendment. And so while where I come from at Yale, I have no constitutional protections for my academic freedom. You actually do, because you are in a state institution. And the court has been quite robust in its rhetoric about constitutional academic freedom. It has said, and I'm quoting it now, this is 50 years ago, the court said this. It said, academic freedom is a special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classroom, ringing rhetoric. When you actually go and look at the cases that are decided about academic freedom as a constitutional value, you will find, to put it bluntly, that they're a mess. They are impossible to decipher. They are all over the map, so much so that one very eminent commentator has said, and I'm quoting now, there has been no adequate analysis of what academic freedom the Constitution protects or of why it protects it, whatever it is. Lacking definition or guiding principle, the doctrine floats in the law, picking up decisions as a hull does barnacles. That is actually not too extreme a description of the disarray in which the constitutional law of academic freedom presently sits. And in this lecture, I wanted to give you a diagnosis of why we have this anarchy in the law, and also a prescription about how that might be fixed. So to have a good theory of academic freedom, you have to know why you want to protect it. What are the principles, ideals that you want academic freedom to uphold? And when the court speaks about constitutional academic freedom, it thinks it has a theory. It says, and I'm quoting it now, the classroom is peculiarly the marketplace of ideas. The nation's future depends upon leaders trained through wide exposure to that robust exchange of ideas which discovers truth out of a multitude of tongues rather than through any kind of authoritative selection. So the court imagines it has a theory of why the Constitution protects academic freedom. That theory is the marketplace of ideas, and I'm going to argue in the 30 minutes I've been given that that theory is utterly wrong. And that theory is so wrong it leads to the chaos you see in the doctrine, and I'm going to suggest to you how the theory might be reformulated. So to understand the problem, we have to go back to the origins of the other aspect of academic freedom, the academic freedom that's in the APM here at Davis, the principles by which we as a university organize ourselves to protect our ability to pursue our profession, the scholarly profession. And that ideal of academic freedom actually in the United States is about 100 years old. It used to be that higher education in the United States in the 19th century was a school for the formation of character. Young gentlemen used to go to Harvard and Yale. They used to be taught their Christian ethics. They used to be taught which forks to use. They were finished, and then that was their education. Around the time of the Civil War, a number of Americans went to Europe, and they there encountered a new institution, the German Research University, which was actually dedicated not to being a finishing school, not to Christian ethics, not to the formation of character, but to the increase of knowledge. And they became enchanted with the German ideal of Wissenschaft, the organized presentation and systemization of knowledge. And they brought that back to the United States. And now everyone in this room, I am sure, considers banal and unobjectionable Karl Jasper's claim that the university is the corporate realization of man's basic determination to know. Its most immediate aim is to discover what there is to be known and what becomes of us through knowledge. But that, in the 19th century, was not the American ideal of the university. It becomes it at the very end of the 19th century, and this is a major shift in American higher education. So it is a great moment when the past president of the UC system, Daniel Coit-Gilman, addresses Johns Hopkins University in 1885, the first university in the United States formed on the model of the German Research Institute, that is to say, formed to dedicate itself to Wissenschaft. He addresses in 1885 the students, the faculty, the friends, the officers, and he asserts with great confidence and at great length, he says, I'm quoting him now, the functions of the university may be stated as the acquisition, conservation, refinement, and distribution of knowledge. It is the business of a university to advance knowledge. This is a major shift in American higher education and what we presently recognize as academic freedom, what anyone in this room would recognize as academic freedom, is a result of that shift. The shift from a higher education which was character building to higher education which is wissenschaftlich, which is the creation of new knowledge. And of course, the person who theorized this most sharply and effectively was John Dewey. And John Dewey is saying in 1902, the moment at which American higher education is shifting in this direction and the moment at which American principles of academic freedom are coming into focus and being, he says this, in discussing the question summed up in the phrase academic freedom, it is necessary to make a distinction between the university proper, and when he says university proper, he means the German Research University, the university proper, and those teaching bodies, called by whatever name, whose primary business is to inculcate a fixed set of ideas and facts. The former, the university proper, aims to discover and communicate truth and to make its recipients better judges of truth and more effective in applying it to the affairs of life. The latter have as their aim the perpetuation of a certain way of looking at things current among a given body of persons. Their purpose is to disciple rather than to discipline. The problem of freedom of inquiry and instruction clearly assumes different forms in these two types of institutions. All right, so on the one hand, you have the institution which disciples. What does it mean to say disciples? It means I am teaching you to reproduce what I already know. So an example of that would be at Stanford University, which was a proprietary institution owned by Leland Stanford, and along comes an economist who teaches the silver standard, and Leland Stanford says, I don't want anyone teaching the silver standard. I know the gold standard, so I fire this person. Person is fired, right? And so the idea is Stanford University is there to give you the truth that Leland Stanford already knows. It's not there to discover new knowledge. Such a university creates disciples, people who can reproduce what Leland Stanford wants them to know. And in contrast to that, the real university, says Dewey, the university like a university as UC Davis, doesn't disciple, it disciplines. So what is it to discipline? What does it mean to discipline somebody and have them participate in a discipline? I'm going to suggest to you that somebody who is disciplined in a discipline like, say, physics, has two aspects to their character. The first is they have to be able to think new thoughts. They have to be able to be critical. They have to do what Kant said in What is Enlightenment? Think for yourself, sapere ardere. You have to be able to criticize and be independent. But second, you have to be able to do that in a discipline. Someone who is in a discipline doesn't give a dreamscape. Someone who is in a discipline speaks in ways that is recognizable to and persuasive to others in a discipline. A discipline is a peer group. And someone who is disciplined is always speaking to others and peers who are in the discipline, who measure and assess the persuasiveness, accuracy, competence of what someone in a discipline says. So we have these two odd in tension with each other, but nevertheless both necessary components of someone who is disciplined. The first aspect of it, the critical thinking, is obvious to us. That's what we all think about. If I had to ask you about academic freedom, you would all say the freedom to think independently. And that part seems clear. Arthur Lovejoy was one of the first great thinkers about American academic freedom. He put it this way in 1930. He said, the university's function of seeking new truths will sometimes mean the undermining of widely or generally accepted beliefs. It is rendered impossible if the work of the investigator is shackled by the requirement that his conclusions shall never seriously deviate either from generally accepted beliefs or from those accepted by the persons, private or official, through whom society provides the means for the maintenance of universities. Academic freedom is then a prerequisite condition to the proper prosecution in an organized and adequately endowed manner of scientific inquiry. Right? You can't, to the basic thought here, quite clear, you can't make new knowledge unless you can criticize old knowledge. And this notion of academic freedom is quite clearly expressed in the first, and in my judgment, the greatest expression of academic freedom in the United States. It is the 1915 Declaration of Principles on Academic Freedom and Academic Tenure. It's authored by the AAUP. We have with us today the present chair of Committee A of the AAUP. And this document, which is the most comprehensive and thoughtful articulation of the principles of American academic freedom, quite explicitly adopts the notion that you need freedom of critical inquiry. Now, I should back up for a minute and say the Declaration defines three aspects of academic freedom: freedom of research and publication, freedom of teaching, and freedom of extracurricular speech, the freedom to speak out as a citizen outside the university. Today, we are likely to add a fourth component: freedom of intramural speech, the freedom to talk about matters of internal university governance. In today's lecture, I am only going to talk about the first and simplest aspect of academic freedom, which is freedom of research and publication, which, when you look at it hard enough, has its own difficulties. So the Declaration, when it looks at academic freedom of research, says, yes, of course, we need critical freedom. It says, because a purpose of higher education is to promote inquiry and to advance the sum of human knowledge, universities must award faculty complete and unlimited freedom to pursue inquiry and publish its results. Such freedom is the breath in the nostrils of all scientific activity. Right? So that part is clear. What about the other part, the part of being disciplined? Where does that come in? If you look at the Declaration, quite interestingly, it explicitly repudiates the position that academic freedom implies that individual teachers should be exempt from all restraints as to the matter or manner of their utterances, either within or without of the universities. Academic freedom doesn't mean you can say what you want. Instead, says the Declaration, academic freedom implies, quoting, the liberty of the scholar within the university to set forth his conclusions, be they what they may, conditioned by there being conclusions gained by a scholar's method and held in a scholar's spirit, that is to say, they must be the fruits of competent and patient and sincere inquiry. Now, that's a really interesting set of qualifications. What does that actually mean? Let me give you some of the institutional structures that actually implement what the Declaration is saying there. So you have somebody coming up for tenure. Can you evaluate the content of their speech for competence? Of course you do. Every university evaluates the competence of its members. And they evaluate the competence of the members for decisions like promotion, for decisions like tenure, for decisions like grants, etc. Let me just contrast that with what it would be like if you talked about a true right of freedom of expression. So suppose you have a young astronomer in your department, and this astronomer writes an article saying the moon is made of green cheese. Get tenure? I don't think so. It doesn't get tenure. So the university can regulate that speech based on its content, based on its, most importantly, on its competence. Suppose that same astronomer writes that same editorial for the New York Times. Can the state say you are misleading the public by saying the moon is made? No, because in the New York Times, it's a right of freedom of speech. You can say whatever you want to say. That is not true in a university. In a university, when we're talking about being disciplined, your speech is always subject to the disciplinary evaluations by peers. Who are your peers? Those who know the disciplines. That's why we have peer review. That's why administration doesn't make decisions of academic competence. Only those who are already academically competent can make the judgment about academic competence. And academic freedom means you are entitled to be judged only by your academic competence, not that you're not entitled to be judged at all. And that is why the Declaration, when it reaches its summation, upholds, quoting now, I'm quoting 1915, not the absolute freedom of utterance of the individual scholar, but the absolute freedom of thought, of inquiry, of discussion, and of teaching of the academic profession, qua profession. And is that distinction which is crucial. Let me contrast that distinction to the marketplace of ideas theory of the First Amendment with which we started. So the marketplace of ideas theory of the First Amendment begins in November 1919 in a famous dissent by Oliver Wendell Holmes in a case called Abrams versus United States. And he says the best test of truth is the power of it to get accepted in the marketplace of ideas. It's a kind of variant of the old Millian position. And the function, it is often said, of the marketplace's ideas that everybody gets to talk so the truth will come out. Everybody gets to talk, so no one gets to regulate on the basis of content, on the basis of competence, on the basis of truth. None of that is relevant because everyone has an equal right to say whatever they want to say, and the thought is the truth is going to come out if you do that. So do we actually think that the truth will come out? I mean, contrast the marketplace of ideas theory in that way with disciplinary thinking. Suppose you were the editor of a professional journal like Lancet or Nature or the American Economics Review. Would you pick your articles on the marketplace of ideas theory? Like any article, whatever it comes in, first come, first serve? If you were doing grants, is that the way you would give grants? If you were doing tenure, is that the way? We would lose the very essence of disciplinary knowledge were it to function under the marketplace of ideas theory. So disciplinary thinking tends to be hierarchical and peer-reviewed. Marketplace of ideas is individualistic, and everybody is equal. And so we say in First Amendment doctrine, there is no such thing as a false idea under the First Amendment because the First Amendment is committed to robust and wide open debate about matters of public concern. Well, that is not the way that we work in the university, because if there's no such thing as a false idea, then there's no such thing as a true idea. And if there's no such thing as a true idea, you can't very well increase knowledge, can you? So we're committed to truth, we're committed to knowledge, and the First Amendment marketplace of ideas is committed to the creation of an open-ended public opinion. And the crucial difference here is opinion versus knowledge. So if you wanted to find out what the half-life of plutonium was, or whether cigarettes caused cancer, or whether there was global warming, would you go to those who are experts in the discipline and ask? or would you crowdsource it by a marketplace of ideas? And I take it in the modern world in which we have expertise, we go to the disciplinary sources of knowledge, which are structured in a framework which is utterly incompatible with the marketplace of ideas. Well, no wonder if the Supreme Court of the United States wants to rest constitutional academic freedom on the marketplace of ideas, it's going to end up with an incoherent mess, because the marketplace of ideas has nothing to do with the way we work in a university. Nothing at all with the way we work in a university. And so, of course, the doctrine of the cases are going to be unintelligible and all over the map, because they don't correspond, actually, to the kind of social formation that a university is. So if that's true, can we develop any, that's my diagnosis of why the doctrine is a mess, can we now make a prescription and see, is there a way to reformulate First Amendment doctrine in a way that makes it compatible with what we do in a university, what the kind of academic freedom we actually care about and practice in a university? So to do that, of course, you need something like a theory of the First Amendment. Ralph was suggesting we're going to do a little reading of the Constitution, but I'll be very quick about that because it's kind of technical. So the freedom of speech, what? Protects freedom of speech. So if you wanted a theory of that, you'd probably say, well, I'd want to protect speech, but not what? Not action. So you'd need a distinction between speech and action. Well, if I ask you to define the distinction between speech and action, you're going to find yourself in a quandary very quickly. I mean, the first response is always to say, it's speech if it communicates an idea, and then it's protected by the First Amendment, as opposed to not communicating idea, that's action. So suppose I don't like you and I don't want you in my neighborhood and I throw a rock through your window when you come. I'm communicating an idea. I'm successfully communicating an idea. There's no First Amendment defense to throwing the rock. And so it turns out it's extremely hard to make any useful distinction between speech and action. The people who flew the planes into the Trade Center wanted to communicate a message. They successfully did it. They did not have a First Amendment defense to an act of terrorism. So that's not going to help us to generate a general theory of the First Amendment. We have to reverse it. What we have to say is we protect those dimensions of the world that serve the values we want to advance in the First Amendment. Rather than there is out in the world something called speech and something called action, instead we say we define the difference between speech and action according to the values we want to use the First Amendment to advance. So in constitutional theory, there are typically three values that are attributed to the First Amendment. The first is the marketplace of ideas, and it is said that the marketplace of ideas produces truth, and what I just suggested to you is that's not true, at least insofar as truth relates to expertise and to knowledge. It produces something else, but not exactly expert knowledge. A second value typically attributed to the First Amendment is autonomy. We protect your freedom of speech because we respect your autonomy. That turns out also to be very difficult to make work for many reasons, because it would mean you could do anything you wanted autonomy-wise. It's a libertarian theory, which the First Amendment is not. But mostly, we tend to regulate speech in ways that are indifferent to the autonomy of the speaker. So I'm going to use one example, which then we'll follow through on. Suppose I'm your doctor, and you come to me, and I diagnose you with cancer, and I say, here, the best cure for your cancer is Laetrile. You remember Laetrile? That old stuff used to be made from apricot pits, has no effect, whatever. So I give you Laetrile, and you sue me for malpractice. Can I say, oh, it's the marketplace of ideas? I just had this idea, I'm just going to give you this. No, of course not. There's no First Amendment defense against the malpractice for the doctor, even though it's speech, right? It's totally speech, but nevertheless, no First Amendment defense. And contrast that case with that same doctor who cares about Laetrile. He goes on the Oprah Winfrey Show. I know that's old-fashioned, but I don't know what the modern talk show is. But, so he goes on some TV show like that, and he says, I am trumpeting the virtues of Laetrile. It really does cure cancer. Those people in the medical school think they know something, but they're really bound by hidebound science. They're not open to new ideas. Try Laetrile. So some person in the audience, sick with cancer, tries Laetrile, is injured, sues the doctor. First Amendment defense? Yes. What's the difference? The difference is in the doctor's office, the doctor could be speaking, but he's practicing medicine. and we guarantee the accuracy of the distribution of knowledge in the doctor's office. When the doctor's on Oprah Winfrey, speaking to the public, and First Amendment protections, the marketplace of ideas, all of those values I was describing kick in when people talk in public. And why is that? The best explanation I can give you is a primary purpose of the First Amendment is to protect democracy. What is democracy? Democracy is a form of government in which state action is responsive to public opinion. And if we want state action to be responsive to public opinion, which is to say to me, it's a form of self-governance, then I should be free to participate in the formation of public opinion. And that actually is what most of First Amendment doctrine does. It gives us the freedom, the equal freedom, to participate in the formation of public opinion to the interest of having the government, to the end of having the government being responsive to each of us by virtue of our participation in public opinion formation. Notice, that's public opinion, not knowledge, right? So when we say that everyone is equal and there's no such thing as a false idea, what we're really expressing is the egalitarian notion that everyone has an equal right to self-governance, therefore everyone has an equal right to participate in the formation of public opinion, and the First Amendment is protecting these political, deep, important political virtues. And it's doing it to create that public opinion which is responsive to the population, democratically legitimate. So now you see in the sharpest terms the contradiction I started with, because if the function of the First Amendment is to create the freedom to form public opinion, what could it have to do with academic freedom, whose job it is to create knowledge? Opinion, everyone has an opinion. You know, you have an opinion, I have an opinion, it's equal. That's a political point about egalitarianism. Knowledge, your knowledge and my knowledge, everyone isn't equal. There is a truth to the matter or not, or we do the best we can under it functions according to an entirely different logic. So how can a First Amendment dedicated to public opinion and democracy and egalitarianism possibly have within it the resources to protect the knowledge formation function, which it is the task of academic freedom to do? That's the challenge before us. And I'm going to be very quick and just sketching out to you, if you want. This is all developed, you know, at greater length than I'm sure any of you want to read. But I'll just give you a quick sketch of how you might look at that. The first thought is, yes, self-government is really important. But if the government tells me what I do and don't know, self-government is a farce. If knowledge is a creation of the very government that asks that to which I want to be responsive to me, but it tells me what I do and don't know, then there isn't, then self-government has no theory at all behind it. It's Orwellian. You know, the government induces in me the fantasy that this is true, and then I want what the government has already told me to want. So unless knowledge is a classic liberal separation of ideas notion, unless knowledge, the sphere of knowledge is separate from the sphere of politics, self-governance in any meaningful sense is impossible. Think here in science of Lysenko. Those of you who are biologists might know Lysenko, right? So, and this is Soviet Union and Marxist, and therefore everything has to be environmental, and therefore there could be no genes, because that wasn't environmental. So he was Stalin's biologist, ruled out the study of genetics because he knew politically that you couldn't have such a thing, and sets back Soviet biology 20 years. Right? If the political controls the sphere of knowledge, you cannot have self-governance. And the political theorist who thought most deeply about this is a French person named Claude Lefort. You might have heard of him. He argues that in democratic states, we distinguish democratic states from totalitarian ones because in democratic states, quote, in totalitarian states, quote, a condensation takes place between the sphere of power, the sphere of law, and the sphere of knowledge. Knowledge of the ultimate goals of society and of the norms which regulate social practices become the property of power, and at the same time, power itself claims to be the organ of discourse which articulates the real as such. So a state that controls our knowledge controls our minds, and because we're actually dedicated to democratic self-governance, we have a constitutional objection to that. We can theorize that objection in terms of the value of democratic competence. I need to have certain epistemological competences, including knowledge, in order to know what to ask of my government, in order to know what direction I want to give my government so that the government can be truly responsive to me. And if you look very carefully at various aspects of the First Amendment, you will actually see this in motion. You won't see it in public discourse, which is committed to public opinion, but you will see it in the doctor's office example I gave you, right? The law is committed that the doctor must transmit true knowledge. Now, suppose you have a state that tells the doctor they have to say something false. For example, in Texas, a doctor who has a patient who wants an abortion must be told that abortions cause breast cancer by the doctor. False. Does the doctor have a First Amendment claim? Yes. Even though the doctor has no First Amendment defense against the malpractice for Laetrile. Why? Because when we're enforcing malpractice, we're upholding disciplinary standards of knowledge, but when a state legislature comes in and says to the doctor, you must say something false or you can't say something that's true, then you're interrupting the circulation of knowledge outside of the sphere of public opinion, and that suddenly becomes a First Amendment question, and we see that in various aspects of the doctrine. And it's my view that if we're going to have a coherent account of constitutional academic freedom, we have to build on that notion. And what is special about that notion that applies to universities? Why is academic freedom, the constitutional commitment to academic freedom, so central to this idea? It's very simple. There's only one institution in the United States after World War II that is committed to the upholding, the maintenance, the refreshing, and the health of disciplinary standards. So how do we know something is true under conditions of expert knowledge? We know it by the best application we have of the relevant disciplinary standards, whether it's nuclear physics or biology of whatever it is. It's the standards which define what is knowledge and not knowledge. So knowledge is produced in lots of places. It's produced in corporations, in Xerox PARC, et cetera, but only one institution is devoted to the standards themselves. What counts as a standard by which knowledge is to be assessed, and that is universities. We reproduce it through the PhD system. We create the disciplinary societies, which are the guardians of these standards. The university is the center, the nerve center of the disciplinary standards by which we recognize expert knowledge in a post-World War II world. And so if that's correct, then constitutional academic freedom should be devoted to the protection of the integrity of the disciplinary standards that allow us to know what is and is not knowledge. And if we adopt that point of view, I just want to say two quick things, then I'll stop. One, it will solve a lot of the puzzles you see in the case law about academic freedom. So for example, a big debate in courts is whether academic freedom applies on the one hand to the university or on the other hand to the professor. So the professor claims academic freedom and a court will say only the university can claim academic freedom. Or the university will claim academic freedom and the professor will say, no, I want academic freedom as against the university. And if what I've said to you now is correct, then both sides are wrong. They're both missing the point. Academic freedom protects neither professors nor the university. It doesn't protect buildings that have the name university over the door. It protects the disciplinary standards by which knowledge is recognized and established. And if a university is protecting those standards against state regulation, or if a professor is protecting those standards against university regulation, that's where the Constitution should attach, to the standards themselves, qua standards. So that's one point. Second point is this. Often courts will test whether a professor has constitutional academic freedom on the basis of the following test. Did what the professors say concern a matter of public concern? Was it about a matter of public concern? If the answer is yes, then the professor can make a claim of academic freedom. Now, I want to suggest to you that test is completely and utterly inappropriate to constitutional academic freedom for the following reason. All state institutions regulate speech within the state institution. If you're in a bureaucracy that gives Social Security checks, you have to regulate your employees in order to give the Social Security checks. But at the same time somebody's your employee, they're also a citizen. and they should be able to speak freely as a citizen. The test of public concern marks the limits of the managerial domain of the state bureaucracy and the domain of the citizen, public opinion formation. That has nothing to do with academic freedom. You could be a professor of Hittite and talking about tablets, and it is not a matter of public concern because who the hell cares? Nevertheless, it's about the application and reproduction of the disciplinary standards and what they tell you is true or not. And whether or not it's a matter of public concern, totally irrelevant to whether one should have academic freedom in order to say that. Now, there's a lot more I could go on. There's much more I could say, but that just gives you a sketch of the ideas. Thank you. Where do you want me up here?
Thank you very much, Dean Post. We have 2 microphones at the back there, and for the next 25 minutes, we're going to take questions from the audience to Dean Post. So please just raise your hand, and they'll come up to you with the mic, and you'll be able to ask your question.
You mentioned that as faculty members, we have the right to create new knowledge and publish the results. In that process, who owns or who has the right to the research materials which are needed to complete the work that's ongoing and then eventually get that result published?
So the question was, in case you all didn't hear it, who has the intellectual property rights to research material and production? And this has never come up typically as an academic freedom question. It's come up as a contractual question of who owns the intellectual property as between the professor and the university. And I am not an expert in intellectual property. I can tell you that there are now inconsistent regimes as between patents on the one hand, where many universities by contract take patents in works done with university facilities, and copyright, where no university takes the copyright on a professor's book that's written with the university's computer. These are not intellectually consistent standards. And I think one of the great challenges of the future will be to work that out. At the moment, it doesn't tie in to any particular theory of academic freedom except at the extremes. At the extremes, it's obviously the case that if I'm writing an article and the university says it owns my article, that can't be right. But in the patent world, that's not unusual, my understanding is. Yeah.
Yes, when there is a patent issued, the university is very careful and they are generous in providing part of the proceeds to the faculty and the grad students who produce the results. My question was, before that process happens, before a patent is issued, can the university claim that whatever you do on our campus, we own it, we can come and take it and do whatever we please with it?
Well, if you state at that level of generality, the answer is plainly no. Because if I'm writing something before I write it, I'm not a writer for hire for the university the way I would be if I were an employee of General Motors. And that follows from the function that I'm performing. But exactly how that gets worked out, I mean, everything that you're talking about there gets worked out in the details. And that's uncertain, I would say now. That's in the process of being negotiated. Would you agree with that, Hank?
Yeah, although there's a specific with respect to the University of California, but maybe we can talk about it.
Yeah, I mean, IP is not particularly my area, but I can tell you this has not been particularly well developed in the context of academic freedom analysis, but in terms of the contractual relationships between employees and the university.
Can you hear me?
Yes.
Thank you for making a very clear distinction between the creation of public opinion and the creation of knowledge. Can I interpret that to mean that academic freedom does not cover situations in which academic units promote particular political agendas?
Well, if you put it that way, the answer would be the academic unit is not created to pursue a political agenda. On the other hand, what academic units do often have political implications and can be viewed as part of an agenda. So that's a tendentious way to frame the question in a way in which it's hard to give a concrete answer. So when I was at the UC system, when I was at Berkeley, the case that came up that changed the APM regs was known as the Intifada curriculum. And it was a case in which graduate students did, I think it's like English A, it was at Berkeley, I don't know what you call it now. If you don't score enough on the English SAT side, so you need writing. And they would farm it out typically to graduate students. So this one graduate student taught a course on the poetics of Palestinian resistance. And it was readings in Palestinian literature. The course description was highly contentious, saying, you know, for 50 years, Jews have killed Palestinians and slaughtered and taken land, blah, 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 all the way down. So we're going to study the poetry of resistance. Last line, and conservatives need not apply. Right? So conservatives need not apply is inconsistent with academic freedom because whatever your political agenda is, it's open to everyone at the university. You can't make the distinction based on political belief, first. Second, if you were teaching the Palestinian literature in order to create workers for the Palestinian liberation, that would be an abuse of the teaching function. On the other hand, it is not an abuse of the teaching function to read that literature with a genuine literary appreciation of its merits, which may have, as its effect, but not its direct effect, a commitment to the Palestinian cause. Right? So how one characterizes this as everything.
Thank you very much, Dean Post. So part of the story you tell seems to be a happy story for us UC professors. We're at a public university. We are therefore able to call upon the constitutional underpinnings that protect our academic freedom, which seem to protect us, even give us more insulation, perhaps even than a private university like Yale or Stanford. But the worry, I think, of a faculty member like me is that because we're at a public university, all our communications, all our materials, and this refers back to the previous gentleman's question, might become available, might be claimed to be publicly available. Of course, in the formulation of knowledge, you need frank interchange, and the idea that interchange might be reviewed in the future might be quite dampening to knowledge development. So I just wanted to talk about that.
Yeah, so I mean, that is an argument of practical effect, chilling effect. If you have a certain amount of exposure, it's going to chill my ability to do my job. And that and the effectiveness of that argument is going to depend upon the effectiveness, I mean, the reality of whether it would or wouldn't chill you. And we have vastly different degrees of exposure, and we know something about the relationship between exposure and the ability to do work. I can remember when I was at Berkeley, some organization, I forgot its name, had decided to monitor every classroom and report on whether, you know, you can do that with cell phones, report on whether this was liberal bias, whether this was actual, and people viewed that as really intimidating in the classroom, and I certainly identified with that. So that was like, that's too much. On the other hand, if they're subpoenaing your grant proposals, or like your salary is public, at Yale, the university would explode where the salary is public. So a lot of this depends on the ecology, what people are used to, and the credibility of the claim of the loss of anonymity will cause the chilling of the work. And I don't think there's a general thing to be said about that. I think it's going to be case by case myself.
I really, really want to believe your thesis about that there is a fundamental difference between discipline management versus egalitarian openness of opinion. However, we've carried out a worldwide experiment that I would argue has refuted that and puts us all in jeopardy from that perspective, and that is Wikipedia. Head-to-head, Wikipedia beat Britannica. Head-to-head, you know, like it's been published in Nature. Britannica was discipline, professors producing truth. Wikipedia was the marketplace of ideas, and it outperforms the production of truth compared to academia and discipline. So we know the marketplace of idea can produce truth better. in that case, right? It has,
No, we don't.
You don't think Wikipedia is, so you don't think that case?
No, what Wikipedia does is it reproduces what is known. So the criterion for posting on Wikipedia is verifiability. Query, how do you know it's verifiable? Query, where does Wikipedia get the knowledge it puts there?
Okay, so basically what you're saying is with the discipline assessment, whoever it is that has the authority to determine whether what you're saying is free or not, they can't necessarily judge the words as proven knowledge. They're just judging the critical thinking, and if you've applied a process, then...
Right, so what they do is, was it published someplace? And they have Wikipedia has a hierarchy of sources, peer-reviewed being the highest. Why? Because that, at some point it's got to come down to, if, suppose you ask Wikipedia, what is the half-life of some new element just discovered? Just because you crowdsourced it, there's no reason to think you're going to get the accurate answer. The reason you get the accurate answer is someone on Wikipedia knows to cite to the right scientific article, which has been peer-reviewed, and the knowledge subject to disciplinary standards. So Wikipedia is a great medium for the distribution of what is known. It's not a medium for the creation of new knowledge.
So my question actually is a follow-up on a question of contracts, which is, what happens when academic freedom comes into contrast with contract law, grant-funded contracts that have stipulations on restricting?
Yeah.
Where do we fit into the discipline and the administrative aspect of the university?
So an article I wrote, I don't know, maybe 12 years ago, they had, I think they were Title IX monies, the regional studies money, and at that point they had just introduced an amendment that had passed Congress saying, if you're going to do regional studies in the Middle East, you have to do it in a way that's balanced as between Israel, because they was afraid that it was too political. And my position in that was it would be unacceptable for a university to accept as a contract matter that grant, because that would be somebody from the outside dictating to you your view of how this should be treated. So my answer is that our academic freedom principles tells us what contracts we can and can't accept.
I guess on this campus, there are cases we're dealing with where sponsored programs, the Office of Research, is not applying. It seems not to be applying a consistent standard of recommendations for what Senate or non-Senate faculty can and should accept.
Yeah, I don't know the answer to that question. I mean, there used to be at Berkeley a rule saying you could not accept money if you couldn't publish the results. So we never got any classified research grants because it had to be because the whole point was to do research in public. There's some debate about that, but whatever it is, you want to think about your responsibility in terms of creating and distributing knowledge, and those should be the criteria by which you determine what grants are acceptable or not.
So I'm an oncologist, so I appreciate your practicing cancer from the podium, cancer medicine. It's good.
Don't take Laetrile.
So, if you could equate the knowledge that you're discussing with the term conventional wisdom, one of our perhaps goals or responsibilities in academics is to challenge conventional wisdom. And in health sciences, we've been wrong, our knowledge has been wrong over and over and over again. In cancer medicine, etiology, application to case law, and malpractice has changed dramatically as we've understood more. And in addition, for example, we know that ulcers are caused by bacteria, not by stress. So in fact, our academic freedom translated into action is most difficult when we're challenging current answers,
right? Because
current answers are often very, very wrong. So
right.
And those new ideas often emerge out of the marketplace of ideas, and it becomes difficult to sell your idea in the marketplace when you're challenging oftentimes the conventional wisdom. I wonder how you
negotiate that.
How you negotiate that seeming paradox, which in fact is not a paradox if you think of it as in fact our core responsibility.
So when I was chairing the Academic Freedom Committee at Berkeley, I had a case come up where there was an architect who was a very famous architect, and he said that his academic freedom rights were being violated because the architecture department wouldn't permit students to major in him. And he goes, what do you mean major in you? So I'm paradigm shifting. I've totally made obsolete the rest of what my colleagues teach. and I am the new Einstein, and you have to major in me. And what do you do if you're looking at such a claim? And the point is, disciplines exist in this paradoxical situation where, on the one hand, it has to be peer-reviewed, it has to be convincing to peers. On the other hand, when it's new, it may not be. And the best way to handle that is good judgment, and you're going to make mistakes, but you have to be open to both. As Bernard Williams wrote in his book about this, he said, in the end, there may be one case out of 1,000, and you look like a complete jerk, and there's nothing you can do about that, except go to the marketplace of ideas. But if you go to the marketplace of ideas, then you no longer have a discipline, you no longer have knowledge, so you can't sacrifice it from that point of view. And that's a risk you have to take, and you have to trust to your best judgment. And there is literally no way, no method by which one can ensure only the right critical claims as opposed to the crazy critical claims get accepted, because by hypothesis you don't know which.
Really quickly, I'm a performance scholar, so half of you, if I could just make a quick intervention, if you feel comfortable, just aim the microphone at your mouth, because it's 50-50. Okay, but then, so my question actually kind of bounces off of that, coincidentally, in terms of academic freedom when it comes to teaching. As research too, but sometimes disciplines evolve slowly. So I'm wondering what the cases have come up or your understanding of as a discipline evolves and a department is trying to decide what should be taught.
Yes.
It's not just in my field, it's in so if you have a situation where the conversation is, I don't think you should teach that, that's not what we feel is the canon or the kind of practices that are interesting, and then new courses evolve, but it's not teaching what some folks feel the discipline actually is.
Right.
And it can be quite difficult, not only in performance studies, but that's why I'm asking.
Everywhere. I mean, the difficulty with freedom of, academic freedom of teaching is if you look at disciplinary norms, they're pretty well established. They're internalized. People have an idea of what statistics should look like and not. Teaching, it's much more anything goes. We have much less of a professional sense of what's proper and improper, so it's harder to make these judgments, and they could become seemingly more political when we do that. That's one issue. A second issue is who gets to make those determinations. And typically, I've talked about research as the researcher. Teaching, the appropriate unit may be the department, so the department says we're going to have this sequence of courses. And it's there that the professional judgments are made about what's appropriate for teaching, not in the individual. So there is no theory to separate which is the appropriate one. I think a major distinction that's come to the fore with the critique of people like Daniel Horowitz and the right wing is that there is a difference between teaching and indoctrination. So indoctrination is you have to repeat to me what I said to you, and teaching is you think for yourself. And then you have to have a theory of what it is that education is supposed to do at the higher level to know what is professionally required. And I think, in the end, that's a very difficult thing to do because it depends on the norms. So if I'm teaching you of the disciplinary norms, so if I'm teaching you math, and I say, what's 2 + 2? And you keep saying 5, and I say, no, you have to say 4. That's not indoctrination, that's teaching math. But if I'm teaching you, Moby Dick, and you say, actually, Ahab isn't Andrew Jackson, it's really Daniel Webster, I don't get to say, no, it's really Andrew Jackson, because that's not the way that the norm of knowledge in literary criticism works. So I think there's a very complicated relationship between the norms that define what it is to know in the area and the norms that distinguish indoctrination from appropriate teaching.
Just a really quick follow-up.
Absolutely.
That's great. Then if you're having this conversation of what should the introduction to theater class contain, and someone's saying it should be this canonical material, and someone else says actually you could include performance art or avant-garde. Does that
So the one thing that's clear is the president of the college doesn't get to tell you that. The alums don't get to tell you that. Who gets to tell you that are your professional peers. Now, the question is whether they do that in a corporate capacity as your department or whether they say to you, you decide. That tends to be different in different universities.
I'm tremendously attracted to your competency-based analysis of academic freedom. and the distinction between that and the protection of expressions of opinion or contested content in the conventional free speech arena. I want to press you to expand the application of the competency approach to something a little more nebulous than the rate of radioactive decay of plutonium. Many of us in the academy, you and I included, deal in aspects of political theory and essentially contested concepts such as justice, democracy, and law. And I'm wondering whether the competency-based approach there leads to no regulation at all, and that makes me think of the problem of hate speech. If I'm advocating a view of justice or democracy or law, I could imagine an advocate becoming so extreme that issues of the suppression of others' autonomy would come into being. So how do you deal with those competency issues in the arena of political debate?
Well, those are complicated issues. I was once addressing a meeting of the National Association of Humanities Councils, and I was making the argument that humanities should conceive themselves as a discipline, as you actually know something. When you've been training for the PhD, you learn something, you learn to distinguish good from bad work, and it's not just charismatic. And a number of people in the humanities will argue that you hire an English professor because they're a wise person. And they're just a wise person, and that's why you should listen to them and give them academic freedom. The right wing says, people like Daniel Horowitz, who are attacking academic freedom, say, why should the state pay someone to be a wise person? Why pick that person? Why not somebody else? What justifies their immunity from academic freedom? I think so long as the humanities takes the idea that their authority is like the artist, it's charismatic rather than it's disciplinary, they basically waive their right to academic freedom. So that's a very important thing. I remember, and if you look at, for example, a scientist, you don't have to be a great physicist to be respected as a physicist. You could do your job of work and people will respect it. But if you imagine that to be a great humanist, you have to be wise, or to be a humanist, you have to be wise, and you have no disciplinary method, then if you're just Joe Schmo teaching at this university and you're working on, Flaubert, then why should anyone pay any attention to your work at all? The lowly physicist gets respect because he's viewed as someone who has internalized and can forward a discipline. If the humanities say the only test is the charismatic authority of the artist, then 99% of the people who teach humanities should get and do get no respect at all. I remember after that I had some people come up from humanities centers in the South, and they said, but we do have charisma. We can show Foucault or Derrida. And it was like, the bones of the saint in the sacristy, we're touching Foucault. I do think that in the law school, we know the difference between competence and incompetent work. And if I didn't think that, then we shouldn't have academic freedom. I do think it's much harder and it's much more different than, it's much more difficult to tell than the easy example I was giving about plutonium, but nevertheless we know it. We know it when we see it. And if we didn't, then we would be fraudulent in claiming what we claim.
Thank you. This has been both enlightening and befuddling. I'm now entirely convinced that the laws are in fact a mess and that we need some wise...
Sorry.
You've convinced me that the laws are a mess and that in fact we need some great wisdom in the courts to unmuddle the academic freedom issue. We've been focusing almost exclusively in this conversation, and rightly so, on the academic freedom of academics, of scholars. I'm in Middle East, South Asia studies, anthropology, and women and gender studies, and we tend to have very active students whose issues of academic freedom also gets raised in complicated ways, because we in fact want to encourage them to be active citizenry, and that involves politics and engagement in the society. So could you talk just for a few minutes about what are the academic freedoms of students? And I'm talking both about graduate and undergraduate students.
Well, in the German tradition, there was Lernfreiheit and Lehrfreiheit. One was students, one was faculty. When we took over only the faculty. And Hank will correct me if I'm wrong, but my view of student academic freedom rights in the United States, radically undeveloped, and they tend to be the negative image of faculty academics. So you have a right as a student to be judged on the quality of your work and not the color of your skin, blah, blah, blah. You have a right not to be abused because the faculty member is forbidden from abusing. So you take all of the obligations and responsibilities of the faculty, you put them in a negative, and you call those student academic freedom rights. But there isn't, so far as I know, any statement, any development of what those rights are independently of that. It's actually an extremely confused area, in my view. I've never studied it systematically, but every time I've looked at one of these Student Bill of Rights, either it's a right-wing thing or it tends to be the negative of the faculty obligations and responsibilities.
Actually, continuing on the subject of students, one of the things that's concerned me over the last few years is I feel as though we are misinforming our students and miseducating them about actually the First Amendment, but of course it all gets mixed up into this concept of academic freedom and the First Amendment. Part of our emphasis on campus is civil discourse, which is, of course, a wonderful thing. On the other hand, the flip side of civil discourse is that it's somehow becomes improper to disagree with people. And so it seems as though a lot of disagreement gets translated into hate speech, for example. Could you talk about that a little bit?
Well, so let me talk about hate speech generally under the First Amendment first, and then talk about it in a campus second. So we tend to have the most protective First Amendment speech protections of any nation in the world. No other nation, for example, protects hate speech. And in my view, the reason why our First Amendment developed the way that it did is it developed out of a country that was a multicultural, pluralist country. So imagine if you go back and look at the Chicago Sociology School, say in 1919 when the First Amendment was developing, they had a theory of what they called the public sphere and public discourse. They said, you take a city like Chicago, and it's a bunch of communities, each with its own ethics of what you can and can't say. Little Poland, Little Italy, the Jewish section, the Afro-American section. But Chicago, as a jurisdiction, encompasses all of them. So people have to have a space to go out of their communities, and that means out of the norms of what civility is within their community, and meet in a common public ground. So the public here is in opposition to the community. And in the United States, our First Amendment tended to develop as a protection in the public sphere, which the court defined as in contradiction to the discrete communities, which tended to have rather strong norms about what you could and couldn't say. In public, you could say virtually anything to each other because otherwise the state would be enforcing the norms of one community or another. And because all the communities were equal, all were equally excluded. It's like the Establishment Clause. You know, we have an Establishment Clause not because in the 18th century America was an irreligious country. It was rather we were so religious, every sect thought the other sect would have power, so no one has power. Similarly, in the regulation of speech, every community wanted to regulate the public discourse according to their norms. And the First Amendment, starting in the 1930s, said no community gets to regulate. So the public place is a place virtually without civility, except at the extreme margins. And that's why, and because we have no elite who can come in and say to the public sphere, it's really in our image, which is the way hate speech works in Canada and in Great Britain and in Germany and in France. In each of those countries, you have an elite strata that says, we know what is proper and improper to say, and everyone plays by our rules. In the US, because we tended to be multicultural and anti-elitist, no elite group could say that, and as a consequence, there is a lot of disruption in the public sphere, almost no regulations on the ground of civility, roughly speaking. Now, a university is not public discourse. A university is a place for education. And in my view, you can regulate speech in the university as is necessary in order to accomplish the goal of education. So you have to decide what the goal is of education. So one goal of education is the reproduction of community standards. This is a Durkheimian kind of take, right? So take a nursery school, and a kid goes to nursery school, and you say, don't bite, don't use those names, and no one complains. Why? Because the main function of a nursery school is to inculcate, to socialize young kids into the norms that make them responsible and mature adults. Now, some universities actually understand that to be their role. Many religious institutions understand that to be their role. If that's their role, they will regulate speech one way. Other universities understand their role to be, I'm preparing you for citizenship. So you can speak here the way you would speak on the street corner, and anything you could say in the street corner will go in the university. And if that's your sense of the university, then of course you regulate speech differently. And a third point, which is one more tied to our topic for today, the university is a place where people learn and a place where knowledge increases. And of course there's going to be robust and effective disagreement, but disagreement only works when there's civility that makes it an argument and people aren't throwing banana peels at each other. So we draw those limits. We draw the limits which are necessary for the kind of a disagreement which would be constructive rather than destructive. And a number of universities have taken that tack. The court, in its First Amendment decisions about what can happen in a university, is, as you might imagine, muddled as between these three images. And sometimes they use one and sometimes they use the other. To me, the issue is what sort of place do you want to be? What counts as getting an education in this place? And that's what will guide us in determining what speech is acceptable and unacceptable.
Once again, we want to thank Dean Post for the lecture and for responding to the questions. Before we proceed with our panel, I omitted to acknowledge the presence of the Chancellor, who is here with us today, Chancellor Kastehi. So at this point in time, I'm going to invite the members of our panel, and we're going to take a couple more questions that have been submitted by Academic Senate faculty and Academic Federation faculty. So I'm going to go ahead and invite the members of our panel to come up and take a seat. Professor Roberta Rehm, Professor Reichman, and the Provost, as well as Dean Post. And over the past 4 weeks, we have solicited questions from members of Academic Senate and Academic Federation, and we've selected a few of those questions for the panel, and we let them have the questions ahead of time. In terms of the questions which were asked just now, they cover some of the ground. However, I think it's going to be useful to hear from a representative of AAUP, to hear from an administrator at UC Davis, and to hear from a former chair of the University of California Committee on Academic Freedom in terms of their responses to those questions. And what I'm going to do is I'm going to put a question up and read it, and then each member of the panel will respond as they see fit, and we'll spend the next 30 minutes or so, 30 to 40 minutes doing that. So we have our first question up there, and I'm going to read it. To what extent, if any, does academic freedom protect the decision of a unit of the university, such as an academic department, to publicly take a stand or advocate a position on political issues, such as controversies relating to Proposition 8, the Affordable Care Act, or the Israeli-Palestinian conflict, in its institutional capacity? Conversely, does a unit of the university, such as an academic department, taking a stand or advocating a position on political issues in its institutional capacity, jeopardize the academic freedom of faculty and students in the department who may hold different views on the subject? And I guess we'll start with the Provost.
So you said we can, I'm sorry, we can respond as we see fit.
Yes, as you see fit.
Might I actually request you don't start with me for two reasons? Well, maybe three reasons. One, it's true I'm the provost, but I try to guide myself on all of these issues by people who know a lot more about academic freedom, but also people here get to hear me a lot, and we have guests. So I think that my recommendation, if we might, is that we hear from other people, and I will be happy to add if there's really anything else beyond the wisdom, the charismatic wisdom, no doubt, and the disciplinary wisdoms of our guests.
So we'll go to the next person, Professor Roberta.
Oh, well, I can hardly hold myself out to be the most qualified, but what I would say about this question is that academic freedom is oftentimes thought of in terms of protecting faculty members from suppression of their rights or their freedoms in realms of research or teaching or what have you. But it can also represent a larger unit like a department or at a university, an academic institution. However, taking a controversial stand with which other members who have academic freedom may disagree should be permissible, because it allows for, academic freedom allows for the intellectual debate of topics which are controversial. And where academic freedom would be impeded would be if your disagreement with your department, say's, stance led to punishment, led to unfavorable peer reviews that were unfair, or in another way suppressed your ability to express your disagreement. So if taking a stance is in no way suppressing contrary stances from other people in academia who have academic freedom, then it's not a problem, in my view.
I think it depends upon the situation. In general, I agree with Dean Post's assessment of the sort of the tension between so-called individual and group and institutional academic freedom is sometimes false. It depends upon the context. But I think there's another way it depends. For instance, let's say in a community or a state, there is a proposal to require the teaching of to bar the teaching of evolution, or to require the teaching of what's it called again? My mind just went blank in the name of creationism. That's and a biology department at the university is quite upset by this for obvious reasons, and on the basis of their disciplinary expertise wants to take a position against the bill. I think that should be in their right to do that, and it's part of their, in a certain sense, their disciplinary academic freedom. However, if that same biology department wants to take a position on an issue that has nothing to do with their discipline, the examples given, Proposition 8, the Affordable Care Act, Israeli-Palestinian conflict, then I think it falls under the question of protection of extramural speech, that is, speech as a citizen. And citizens can speak either as individuals or in groups. And the department, it seems to me, would be free, perhaps not wise, but free to take a position. Having said that, however, in both instances, it seems to me that that position's limit is limited to the fact that it cannot or should not, under academic freedom, limit the freedom of individual members of that department to disagree with the position, including even within the disciplinary context if they have tenure. Well, even if they don't have tenure, but they will be judged according to that, that they have that right. So I think a department takes a position on something, needs to recognize that an individual member of its department need not. Now, let me give you two examples. One is at another university in California, a public university, in its engineering department, they have a faculty member who is a Holocaust denier. He does not teach it in his engineering classes. It has little to do with his expertise or lack of expertise as an engineer. But he does, on his own independent website, propagate this, and he is known as this. And the department has taken a position that they put on their website, a statement that we understand that this member of our department has this controversial position. We believe it is his right as a citizen to advocate for that position. It is also our right as a department to say that when he does so, he does not speak for us. I think that is an appropriate way of handling it rather than attempting to deny this person's academic freedom. Another issue came up recently around the academic boycott of Israel when the American Studies Association approved the resolution on that. A large number of university presidents around the country, over 100, issued statements criticizing this as an attack on in violation of academic freedom, a position that I happen to agree with. However, a number of faculty who do support the boycott raised an interesting question, is on what right does the university president have to speak on behalf of the university when many of the faculty members disagree on this issue? And I think it's a difficult question. I generally think that university leaders have the obligation to speak out against violations of academic freedom in general, in their institutions and in society as a whole. And in most cases, we as faculty welcome such things. We don't simply say, oh, you can't do that until you go to the academic senate and get our approval. On the other hand, there is the question of the right of individual faculty members to take a different position, including a different position on the meaning of academic freedom. And that needs to be respected.
I agree with Hank. This is a question of what you call extracurricular speech. That's to say the freedom of a professor to speak out as a citizen. Of all the 4 dimensions of academic freedom, this is the most puzzling, because why should a professor have this right when no one else in the society has the right to speak as a citizen and be free from any consequences in their employment? It's actually extremely hard to figure out why this should be part of academic freedom. The canonical documents of the AAUP are quite qualified in this right, don't really understand it. The best way, I think, to think about it is if you're from the professor's point of view, it's hard to know when you're speaking politically and when you're speaking from your expertise. And it behooves the university to create a climate of trust for professors so that they don't have to worry about that. And so freedom begets critique, which is all to the good. Now, if that's true, there is a right for the individual citizen as a professor to speak out, but there's no particular right as a department, as a corporate body to speak out. That wouldn't follow from the rationale that I just gave you. It could be the people in the department get together and as individuals sign this. That's one thing. For the department, quad department, to say this, I wouldn't analyze that as academic freedom one way or the other. I don't think they have an academic freedom right to do it. And I tend to doubt that it penalizes the academic freedom rights of those within the department that disagree, so long as they're not, as you said, penalized.
Do you wish to add?
I think I was right that I would have very little to add to all of this wisdom, but just 2 thoughts. One, and this also comes from Dean Post's lecture, is I think it's clear that very often we and other people use the term academic freedom when it's not necessarily academic freedom in a strict sense that's being discussed. I mean, these are freedoms of all sorts in the academic realm, and that may be different, very different from the strict academic freedom that we have law and various regulations. It just confuses things, but we, of course, have to deal with it. One thing, and we may be having more questions, and I think this very, very timely and interesting challenge of the debate about the boycott and the position that faculty have taken, sometimes within universities, certainly through some professional organizations. It is true, and that Chancellor and I actually joined that group of leaders to oppose the boycott, but I want to make it very, very clear, and we have said this as well, that we absolutely support the right of faculty, both here on our campus and as part of their professional organization, to express their opinions.
Thank you. We'll go on to our second question. And again, I will read the question. Just to make it quick. Academic freedom appears not to be a legally established category, but a constantly evolving and negotiable one. Thus, in the name of an Act to Protect Academic Freedom, H.R. 4009, introduced February 6 with the public involvement of the Israeli ambassador, asked Congress to act to punish the ASA, the American Studies Association, and its supporters and or members for the resolution supporting the boycott, divestment, and sanctions campaign against Israel. Meanwhile, those supporting the boycott, which in fact applies to institutions, not individuals, point out that Israeli universities do not themselves extend uncontingent or meaningful academic freedom either to Palestinians and Palestinian Israelis or to Jewish Israeli dissidents. While the Israeli Knesset passed in July 2011 a law making support of the BDS a civil offense. Support for academic freedom, therefore, argues for a boycott of state-embedded institutions that do not observe or provide the infrastructural conditions in which academic freedom itself might be a meaningful concept. What is the panel's view of this situation, and to what extent is it possible or indeed desirable to postulate a set of conditions entailed in academic freedom that are deemed indisputable and or beyond politics? And once again, we're going to start with Professor Rehm.
Good move. No, I don't know that it's such a great move. Well, okay, I'll start by saying something probably somewhat controversial. I'm not sure that it's possible to create policies and definitions of academic freedom that are without dispute and to outline principles that cannot be contested. I think it might be our obligation as academics to keep the contestation going. But the other thing that I would say about this particular situation is that academic freedom is about academia, right? It's not necessarily a call to action. That might be a controversial statement too. I think it's possible to uphold a principle without necessarily requiring that someone take action such as joining a boycott or supporting a boycott or trying to punish in some way people who hold views that you find abhorrent or that try to suppress a principle that you might think is even more important than academic freedom, like the human rights of Palestinians, say, in this instance. So I think that whenever we try to take away the rights of one group to express their opinions, that eliminates academic freedom in some way, it diminishes it. And so denying the rights of others is not a way to uphold academic freedom, in my perspective.
Let me clarify the AAUP's position on this because we've been in the thick of it, and as a result of our position have managed to sometimes anger people on both sides. The first thing to say is the AAUP has absolutely no position on the Israeli-Palestinian conflict. We do not, as I've often said, have a foreign policy. Carrie Nelson, our former president, once said, we will have a foreign policy when we have the capability of sending ambassadors to all the countries of the world. And as a result, we also do not, as some other organizations do, we do not take positions on alleged violations of academic freedom, be they individual or systemic, in other countries. We have occasionally issued statements, and frankly, some of those times I think we were probably incorrect in doing so. We do not have the resources and expertise to give it the kind of careful study and analysis that we do in the United States. In that light, we do have a position, however, in opposition to academic boycotts. We believe that boycotting a university because of its violations of academic freedom is actually counterproductive, and it also is a question of violating one group's academic freedom rights in order to protect another's. I would say that the statement, support for academic freedom, argues for a boycott of state-embedded institutions that not observe or provide infrastructural conditions in which academic freedom itself might be a meaningful concept. Could be, let's try to apply that here in the United States, because in fact we have, I don't know about state-embedded, we have state institutions in the United States that regularly violate academic freedom. We have a whole long list of them on our AAUP censure list. But we do not advocate boycotts of those institutions, so we actually advocate dialogue and change in those institutions. That said, we also seriously oppose attempts to stifle the academic and, frankly, civil freedom of individuals who do advocate academic boycotts. So with respect to the legislation referenced in the question, we oppose it. We also oppose legislation currently proposed in New York, Maryland, and Illinois, and perhaps spreading elsewhere, that would compel universities to refuse to support travel expenses of faculty to a meeting of an organization that has endorsed an academic boycott. The irony, of course, is that you are traveling to that organization's meeting in order to get it to reverse its position. You would also be denied your funding. We believe this is a political criterion that has no business being made. Of course, universities regularly have limited funds to support travel, and we have, usually in most campuses, probably here too, have elected faculty committees that judge this, or have a system in which a certain budget is given to everybody, et cetera, to use. So we oppose academic boycotts. We think they're a violation. We also oppose these efforts to silence those who advocate academic boycotts.
Yeah, I think I would agree with just about everything Hank said. It's those of you here who teach in a law school will look at the first sentence of this and say, there isn't a legally established category that isn't evolving and negotiable. Such a thing doesn't exist. Nor are there any way to understand a concept of academic freedom that would be beyond politics or indisputable. This question is posing things in a way that it asks the impossible of these concepts. And the second thing I would say is that underlying the AAUP position, I think, about opposing boycotts is the notion that academic freedom is committed to the health of disciplines. And just as when someone is making a claim in a discipline, one judges the claim by its competence and not by its politics, so you would say, dealing with peers who are disciplinary peers, you would judge their contributions by their competence and their relevance to the disciplinary question on the table and not by their politics. Now, of course, you can reach an extreme situation where you would make an exception to that, but on the whole, that should be the default rule. And I think that's what's underlying the AAUP position here.
I would just add that specifically with HR 4009, this seems really quite unacceptable to me. This is an infringement of freedom of expression, freedom of association, and also it is based on content. This seems to be completely inappropriate, as does something, for example, I think it's the legislature in South Carolina withdrawing funds from University of Charleston because it didn't like a book that's been assigned. So I would hope that we would all work together to try to curb aspects of the public or the government that try to do such things that are totally inimical to freedom altogether.
If I could add one quick thing about this, I very much agree with what the Provost just said. I want to add that we in the AAUP have tried as hard as we can to be proactive about this. We have written statements and sent them to every legislator in the states where these laws are coming up right now and in the Congress. We've joined together with the National Coalition Against Censorship and the ACLU to issue statements against these laws. And I want to say we also issued a statement of disappointment, I should say, when the ASA passed its boycott resolution, and we had urged ASA members to vote against it. But on the other hand, the ASA had the right to take the position it did. We think it's an incorrect position, but they had the right, and we made no objection to them exercising their right in a way that we thought was foolish.
reason why it's foolish is because the claim of expertise by the ASA is based upon competence. And this is based upon political judgments. And the minute you start asking, inviting others to evaluate your academic performance based on your political views, you are undercutting the very claim of academic freedom you're going to be asserting in the future. That's why it's foolish, I think.
Thank you. We'll go to our third question. So someone wrote, I have a university computer in my university office. It is attached to the university network. Recently, without warning, a person from IT came by and upgraded the computer. During the process, he or she removed files and programs from my computer. I believe this is a violation of academic freedom in the same way removing research files from my lab or file cabinet would be. Could you please weigh in on the subject of academic freedom and research using university computers? Who controls the data? Professor Rehm, we'll just keep that order.
Okay. You know, this is really interesting because I think there's got to be so much more to this story. You know, the universities sometimes provide us with a computer. Mostly they tell you to purchase it on your grant funds or, you know, with some other money that you control. But that doesn't take away your appointment, which is to work on your research and do the work that you've been hired to do. And so for someone to take the data that allows you to do the work that they're asking you to do is completely, you know, counterintuitive and hard to imagine. I don't think that the fact that the university owns the computer has very much to do with it. If you look on some University of California websites, you will see that there is a claim that our research data that we collect in the studies for which we are the PIs belongs to the regents. That is the raw data. Raw data, in my understanding, can't be copyrighted, and the lawyers can correct me if I'm wrong, but once we manipulate it by writing an article, creating a chart, what have you, then it can be copyrighted. Usually, even if a university claims that they own the data, such as when required by, say, a federal funder like NIH, they are still appointing the PI to manage the data, work with the data, manipulate the data, et cetera. And so to come and take data off of a computer makes very little sense unless there's some kind of imminent danger, which is hard to imagine. Maybe there could be national security issues. Those are certainly in the news plenty these days. So I don't think the fact that the university owns the computer, which it's providing in order for you to do the job that it's asking you to do, gives them any right to take the data.
Recently, AAUP's Committee A, and with approval of AAUP Council, revised our 2004 policy on academic freedom and electronic communications. What we mainly did was expand the document to include much more information, including issues of social media, issues like that. The basic principle of our policy is that restrictions on academic freedom with respect to electronic communications should fundamentally be no different than restrictions in any other form of communication. So, for instance, if the university cannot go into your filing cabinet and take your research files, they shouldn't be able to go into the files on your computer and take them. Now, we also recognize that universities have legitimate interests. Indeed, we all have a legitimate interest in protecting the security of our computers. University systems are often subject to hacking attacks, sometimes in the hundreds of thousands a day, that there are many issues involved there. And in that light, our policy strongly recommends that as we put it in the statement, information technologies policies are too important to be left to the IT personnel. That faculty elected faculty representatives, knowledgeable elected faculty representatives need to be involved in the formulation of those policies so that academic freedom concerns are addressed very clearly in the policies. I don't know what happened in this particular incident, but it's certainly conceivable to me to understand that an IT person comes in to clean up the computer, has no real recognition of what the nature of certain files are, and inadvertently removes them, or is concerned with security things because there's a possibility of a virus by some kind of name or what have you. These are things that faculty need to be involved in. I think it was Monday this week, it may have been last week, the Chronicle of Higher Education published an article about a survey they had done of faculty leaders at a number of campuses, and about half the faculty leaders there reported that their campuses had no policies governing electronic communications and information technology. Of course, it turned out that later in answering specific questions, they acted as if they did have policies. And of course, every university has a policy. As soon as you require a password to get onto the university's network, you have a policy right there. But what they meant was ones that they did not know about. They had not been involved in. And the article actually quoted some people as saying this was a good thing because the less regulation, the better. That was the position of Greg Luciano from Foundation for Individual Rights in Education. They also quoted me, however, as saying that faculty should be involved in having such a policy because when a crisis erupts, an administration is going to make it up on the fly, and the pressure from their IT personnel, from the public, from other things are going to make it more difficult for them to defend academic freedom. So I think the real answer to this is that, yes, the question of access to university computers, how they're used, is intimately connected with academic freedom and therefore needs to be something that faculty governance, that departments, that disciplines need to be involved in.
Everything that's said has been exactly right, in my view.
Well, you know, I'm not going to go into speculating. I do from this presume it was inadvertent, but I think that the issue of security is something that we do need to be thinking about. Just as to be very, very current, on April 8th, I think I'm right about that, Microsoft will stop supporting Windows XP. We have thousands of machines on this campus that still have Windows XP on it, and again, we do have policies and policies that have been derived. We have committees that involve academic senate and other teaching faculty. And we do believe that we have to do everything we possibly can to protect the integrity of the entire system. One of the policies is that you can't have software that's not supported. So how we're going to get to make sure we rapidly get to compliance or have machines isolated, which is also possible. Certainly we don't intend, and I don't think we would have to lose any data. And not to be banal or blame the victim, but it is a good reminder to have backup files.
Yeah. I also wanted to say that during the time that I was the chair of UCAF, there was a university-wide committee trying to establish a policy for the management of electronic data for the UC system, and we sent a representative from the Committee on Academic Freedom to that task force to work with them so that faculty's voice would be represented.
And I might add that in our policy on electronic, which is more a report in some ways than a policy because it goes on forever. That's because I wrote it, but I tend to run on. But we do in that report actually cite, I think it's the same UC policy as a positive model.
Thank you. We're actually going to go to question 5 because I think the responses to question 3 kind of cover some of the ground for question 4. So I'll go to question 5. And it says, should faculty have the unquestioned academic freedom to use a textbook that they have written as a textbook in their class? Or should there be standard procedures across the university but implemented within each department to periodically decide whether a textbook is appropriate for a course? What should the criteria be for deciding whether such a textbook is appropriate? For example, if a faculty member's textbook is out of date, or is much more expensive than an appropriate alternative, or is clearly inferior to an appropriate alternative, does the department have the right to step in and declare that the faculty member must choose a different text?
Are you going to make me start again?
I'm not
Okay. Well, I mean, you all understand, I'm sure, as faculty members, that the curriculum, which includes course content, textbooks, et cetera, clearly belongs to the faculty. It's not an administrative decision. It's not one that can be made by anyone but the faculty. However, in most universities that I'm familiar with, certainly mine, there are collective faculty committees that are responsible. We have a master's level curriculum committee, we have a doctoral level curriculum committee, and we have peer review of teaching. And so I think that there are checks built into the system so that if a faculty member is abusing their right to create content for their courses, there should be some checks in the system to help them to make better decisions.
Let me begin with a little story that was told to me by Jordan Kurland, who Robert knows, who has been working in the AAUP office since the dawn of time, actually since 1965. But some years ago, Jordan told us he got a complaint from a faculty member. I need AAUP's assistance. I want to assign Jack Kerouac's On the Road in my literature class, and they won't let me. Jordan assumes because it was controversial beat literature, so he writes to the appropriate administrator and says, this is the story we've heard, and blah. And actually, I think he may have phoned him. And the administrator says, hold on 1 second. He says, did Professor X tell you that the course was in 19th century American literature? So obviously, faculty do not have the right to use anything at all as a textbook. In general, when faculty individually teach a course, the faculty member is, within the context of the department's or the university's definition of the goals and purposes of that class, should have the right to choose the instructional materials. We recently in Committee A adopted a new policy which we call Freedom to Teach. It's a very short statement. It will be in our new edition of the Red Book, which will be coming out in 2015, our centennial year, in which we had dealt with the question of what about textbooks in multiple section classes? For instance, introductory calculus, English composition, often taught by either a mix of full-time tenured and tenure-track faculty and part-time temporary faculty, or sometimes entirely by part-time temporary faculty. And our position was that the faculty teaching that course collectively, as long as it involves all those teaching the course, or at least expected to teach the course, because we all know every once in a while somebody's hired at the very last minute to teach a section, that as long as they are the ones collectively to determine the use of what textbooks are used, they have the right to do that. And some members of the committee thought that this placed too much restriction on the individual freedom of faculty members. We felt responsibility for the curriculum lies with the faculty collectively. And in such a course, the faculty has the right, if the faculty who are teaching that course, who are responsible for that course, are the ones who decide, not an administrator, not somebody outside of the course. And of course, they're within the guidelines of the purpose of the course and its teaching goals. I think, personally, a wise department might allow for some flexibility there. When I taught introductory American history at Memphis State University, it was a required course of every single student in the university, and when I arrived there, the department had one textbook that everybody had to use. Wisely, I think, the next year we did a review of that textbook, which led the publisher's representatives to go nuts and sort of, dump all sorts of goodies on us in the hope that this would sway our opinion. It didn't at all, but we accepted the goodies. We ultimately decided to legitimize a choice of 3 different textbooks, all of which were popular in the faculty. That was a good step forward. But we did it collectively as a department that offered that course.
So just want to repeat a passage I read to you earlier when we're talking about now the 1915 Declaration, which really creates the theoretical framework for academic freedom in the United States. It upholds not the absolute freedom of utterance of the individual scholar, but the absolute freedom of thought, of inquiry, of discussion, and of teaching of the academic profession. Right? So the question of what textbook to use is a question for the profession, not for the administration, not for the alums, not for the donors, but for the profession. Now the question is, what's the profession? It can be the individual, but it can also be the department, or it could be the people teaching the course. The central issue, so far as it concerns academic freedom, is that it be made on professional grounds by the relevant professional actors who are acting according to their competences. And so some universities organize the assignment of the textbook by the department. Some allow individuals to assign their own. That's within the discretion of the profession. But the key point for academic freedom purposes is that it's the profession making the decision in any of these guises.
Nothing more to add.
Thank you very much. I think at this point we come to the end of the formal part of our Academic Freedom Forum. Let me seize the opportunity to thank once again Dean Robert Post, Professor Emeritus Hank Reichman, Professor Roberta Rehm, and the Provost of UC Davis for participating in our Academic Freedom Forum. Let's give them a round of applause. I would also like to add that there are many questions which were submitted which have not been addressed. The members of the Committee on Academic Freedom will be following up with the members of the panel on some of these questions. Also, please stay for the reception, and you may approach any one of the members of the panel yourself and individually ask some of the questions that you have on your mind. But we are not kind of like just discarding those questions. We are keeping them, and we'll be looking at them. And thank you all so much for coming out this afternoon.